Greetings. My name is Efrén Rivera Ramos. I am a professor of law at the University of Puerto Rico and a member of the Academia Puertorriqueña de Jurisprudencia y Legislación. It is a pleasure to welcome all of you to this conversation about a classic of Puerto Rican legal scholarship that has recently been re-edited, republished by the Academia, and that is Dr. Santos P. Amadeo's book titled Argentine Constitutional Law, first published by Columbia University Press in 1943. I am joined here by the co-authors of the foreword to this newest edition of Dr. Amadeo's book, two very distinguished colleagues who undertook the project of taking a fresh look at Amadeo's text and examine its relevance to legal scholarship, both at the moment when it was published and at the present time. And these dear colleagues are Erin F. Delaney, professor of law at the Northwestern Pritzker School of Law. Hi, Erin.
Hello, thank you for having me.
Thank you for being here. And Christina D. Ponsa Kraus, the George Wellwood Murray Professor of Legal History and the Walter E. Meyer Professor in Law and Social Problems of Columbia Law School. Hi, Christina.
Hi.
Very nice to have you, both of you, here for this session of the Academia. I am really thrilled that you have agreed to participate in this session, and I thank you on behalf of the Academia Puertorriqueña for your valuable contribution to this project. But before we start talking about the book and your foreword to the book, for the benefit of our audience, let me say something very briefly about this project and about this particular author. About the project. The recent publication of this book is part of an effort by the Academia Puertorriqueña to bring to light again and to make known to the present generations of students, lawyers, legal academics, and members of the general public important historical texts, some of which unfortunately have been almost forgotten, by prominent Puerto Rican legal scholars who were very influential during their lifetimes. This book by Santos P. Amadeo is one of those classic works. Now let me say something to remind our audience about who was Santos P. Amadeo. Amadeo, for many decades, was one of the leading lawyers and legal academics in Puerto Rico. He was born in the southern town of Salinas, Puerto Rico in 1902 and died in San Juan in 1980. So his life spanned most of the 20th century. He studied political science at the University of Michigan, obtained his Juris Doctor degree from Northwestern University, where you now teach, Erin, and obtained his doctorate in law from Columbia University, where you now teach, Christina. In fact, this book on Argentine constitutional law grew out of his doctoral dissertation at Columbia. Amadeo taught for several decades at the University of Puerto Rico School of Law, where I teach, and he was interim dean of the school for several years. He went into politics and became a member of the Puerto Rican Senate, and he was also the representative in Puerto Rico of the American Civil Liberties Union, during which time he became, in fact, very, very popular for his passionate defense of the rights of the accused and of political dissidents of all stripes. He wrote a good number of books on several legal topics and received numerous awards for his outstanding professional and academic achievements. And as one of his disciples, who later became a legend of his own, Professor Miguel Velázquez Rivera, said at some time, Amadeo was truly a character who exercised great influence among his students and among his colleagues. And we will now talk about this book, which he published in 1943. So Erin and Christina, you know the book very well, of course. So why don't we start by you briefly describing what was the purpose and what is the substance and organization of this book?
Great, thank you. And thank you for those wonderful opening remarks about Amadeo. So the book in its substance and organization is really what was called in a book review in 1945 as the first treatise on Argentinian constitutional law in English. Mm-hmm. So a very important contribution to the literature at the time that it came out. It's a study of constitutionalism, but with a particular focus on the role of the Argentine Supreme Court. Mm-hmm. And the book has 3 parts. It opens in part 1 with a fascinating history of constitutionalism in Argentina, beginning with just sort of the successive efforts at constitutionalizing mm-hmm. and the numerous players that were involved in that process. Mm-hmm. And then parts 2 and parts 3 really take a deep doctrinal look at how the Supreme Court addressed questions of federalism and then questions of rights. So the book has a little something for everyone. It's got the history, but it also has the law. And it thus makes it fun to read as both a moment, sort of a moment of its time, and to evaluate as things have progressed in Argentina and in comparative constitutional law more generally.
Okay, so he says in his book that his basic purpose is to examine the role of the judicial power in the preservation of the federal system in Argentina and in the protection of rights. So it seems that his focus is on the work of the court in preserving the rights and the structure established in the Constitution. Is that how you read it?
I think that is his sort of secondary purpose. In some ways, there's a meta purpose that overarches the whole book, which is to think seriously about the role of the United States in influencing Argentinian constitutionalism. And so this isn't only in the context of the drafting of the Constitution, but also in the way in which the Supreme Court operates. And is the Argentine Supreme Court drawing on US Supreme Court decisions when, how, and why? So there are many layers to the book, and you, again, can get a lot of different things out of it based on these sort of different goals that he had in writing the book.
And in fact, he sort of stated like 2 conclusions. One was that, in effect, U.S. constitutional law had a great deal of influence in Argentinian law, in the Argentinian constitution and the court itself, but at the same time, the Argentine constitution had its own sort of autochthonous dimension to it, and that it was not merely copying from the U.S. Constitution or mimicking U.S. Supreme Court, but that the court sometimes digressed from that and didn't engage in just doing some superficial imitation of U.S. constitutional law. Did you read it the same way?
Yes, and I should also let Christina jump in. I would just say something that he noted was that when the court identified a provision of the Constitution, the Argentinian Constitution, as coming directly from the United States Constitution, the court would draw more heavily on the U.S. Supreme Court's decisions. When it understood the constitutional provision to come from somewhere else or to be heavily influenced by the constitutional history of Argentina itself, it was more willing to do its own interpretation. So there's nuance in how he understood the role of the court and the court itself understanding its own role in different ways in different contexts.
So I can jump in and just say a couple more words on that subject, and also want to say before I keep talking that it's a pleasure to be here, and I too appreciate your introductory remarks. And it's just a pleasure to be involved in this project of preserving and disseminating the works of significant Puerto Rican authors. So it's exciting to be a part of it. And so I just wanted to add, I absolutely read it that way as well. I believe that Amadeo wanted to and succeeded in offering a balanced, precise, and quite meticulous account of the extent to which the U.S. Constitution was influential upon Argentina's and the extent to which it was Argentina's own. In addition, he did point to other sources of influence, although his focus was the U.S. Constitution. And in addition, he discusses contemporary sources such as Alberdi, the father of the Argentinian Constitution, and others who themselves said, a lot of this is modeled on the U.S. Constitution. We should, borrow as we please and borrow in the manner that is suited to us and not in the manner that is not. So it's quite a measured and careful assessment of the degree of influence, and then areas where there is less so.
Yeah. So you said, of course, that this was the first English book on the Argentinian Constitution. Apart from that, what importance or relevance do you think that the book had in terms of its contribution, if any, to both to comparative law and to legal history, and even to comparative constitutional law? What would you have to say about that?
So I'll say a few things to start. So the first, and for most of the 20th century following its publication, the only substantial English language study of the topic. The reviewers in the moment all note its importance to the field as a clear, systematic source of information on Argentine thinking on the court about federalism and U.S. influence on itself. It was cited, it continued to be cited by comparative works for decades afterwards as one or just a few works of comparative constitutional law looking at Argentina and the U.S. So it has played really a central role for scholars interested in comparative constitutionalism, and in Argentina in particular. It's really an essential source to this day, even though at the same time, as Erin pointed out, it's also a product of its time. So its importance can also be assessed in terms of what it tells us about that moment in the history of comparative law, comparative constitutionalism, and legal history. Yeah.
So it's true. Now, in fact, in your prologue, you cite several of the book reviews written at the time, and additionally, it seems that Amadeo had the backing of very important people of the time before he published the book and when he published the book. For example, in his preface, he thanks the then Argentine ambassador to the U.S. for his support, himself a very well-known scholar in Argentina, and he also thanks, it drew my attention, Nelson A. Rockefeller, who at that time was the coordinator of inter-American affairs for the U.S. government under the FDR administration. So, and also the foreword to the book, to the original edition of the book, was written by Leo Stanton Rowe, that who we know by that time was already a well-established scholar and diplomat. He had been president of the American Political Science Association, and at the time that the book was published was the Director General of the Pan American Union, which was a very well-established and prestigious institution devoted to the promotion of inter-American affairs and the relationship between the U.S. and Latin America. So he had like all these very important people backing him up. Does that tell us something about the book and Amadeo and about the moment that the book was written, even beyond sort of the academic dimension? What do you think?
Well, I wish I knew more on that score. I don't know how he, so I noticed these connections as well. Yeah. And I could speculate as to why such important and wealthy backers would be interested in such a project, but whether it is evidence of Amadeo's sort of ability to navigate institutions, or whether it's about these connections reflect something about the moment in time, I'm not entirely sure. I do know that in this moment there was a resurgent interest in comparative law itself, right. And that is reflected, I suppose, arguably in those connections, and then also in what we learned about developments in the curriculum and what Erin knows about this moment in time in the history of comparative scholarship.
Right. So
I might just add one comment, which is we do know that he spent 8 months in Buenos Aires researching this book. And so my, again, guess, because we don't know for sure, right, is that he must have had some funding to do that.
Yes.
And that, you know, there was clearly interest in perhaps understanding this federal system, ensuring that it was thinking about how it was developing, thinking about ways in which the U.S. Constitution, particularly in the mid-1940s, as you think about the end of World War II, the ways in which the U.S. Constitution might be useful abroad, and how people might draw on that Constitution. And this is very much a moment of its time, as Christina pointed out, and has been highlighted as an example of U.S. constitutional influence. Now, in the 21st century, we see many articles and evidence about the waning influence of the U.S. Constitution. So this could also be sort of a different moment in time as we think about international diplomacy connected to constitutionalism. And
to academic production. So it's sort of, you know, like the role of a sort of academic diplomacy operating there, which was not rare at the time. Well, it's an interesting angle, I guess, to explore at some time. Now talking about the present time, what is your view of the relevance of this book and Amadeo's work for the present time?
And I really want to defer to Christina here because she is the trained historian. But one of the ways in which we approached this project was to think about what it meant to write this at the time he wrote it, the role of Amadeo as author, and then how to think about how to evaluate it in light of that. And that is a methodological approach that really comes out of legal history to better understand the book. And you know, I'll let Christina talk about what that means because she is the historian.
All right.
So absolutely. So the way we approached the project was really by thinking about the book more as a primary source, really, than as a secondary source. So for me, it was an opportunity to learn about Argentinian federalism. I'm not an expert on it. Erin does comparative federalism, but Argentina is not her focus. So certainly we learned plenty, just interesting to read this book. But we got more excited about thinking about Amadeo as a student, as a scholar, as a Puerto Rican. Where was he? How did it feel? What's the context in which he's doing it? What could we learn? And we decided basically to dig around and see what we could find out about just the place where he was. So Northwestern, then Columbia. It was a really nice detail of the project that Erin is at Northwestern, I'm at Columbia. That's where he was. We love working together. It was an opportunity for us to just, talk and snoop around and see what we could find. And what we ended up doing was finding materials that told us a little bit more about the concrete context in which he wrote, which was at Columbia, is ultimately where he actually wrote the initial paper that became this book. As part of a new seminar at the time on comparative constitutional law. He wrote a seminar paper that developed into this book in ways that we found interesting, that we can talk about. But what was, I think, most inevitably intriguing to me was his relationship to the material as a Puerto Rican. So there's him being a student at Columbia, how what's happening in comparative law, and then what is it like for Amadeo to explore Argentine federalism as a Puerto Rican.
And Erin, as a comparatist,
So that sort of that first prong of the duality, what does it mean to be thinking about a comparative project at the time he was writing in the discipline as it existed? That was a part that I found very interesting. Comparative law still today presents some real methodological questions. What is it that we're doing when we're doing comparative law or comparative constitutional law? Are we looking for a truth where we can take away all context and find some immutable fact about law or about humanity? And one thing that is very interesting about the material, so his seminar that he took at Columbia, there's a prologue to those seminar materials, a foreword to those materials written by a legal philosopher at Columbia, Edwin Patterson, and he talks about this idea that really there can be no search for universal truth. What he learns from this set of seminar materials is that everything is deeply contextualized. And so that is a critical moment in the evolution of the methodology of the field. And we see how Amadeo takes that so seriously in the later book, how he really does the hard work of trying not to just draw very simplistic analogies to the US, but actually drawing out the variety of influences in Argentina. So that seems to come from the debates going on right then. And then I had a great time with my librarians at Northwestern trying to figure out our Northwestern dean, a famous dean, Dean Wigmore, also was very involved in comparative law. And he taught a seminar in the late 1920s. And so we were trying to figure out, did he take it? And can we find any evidence of class lists? And so as Christina said, there was a certain excavation and fun aspect to this for me. But again, that seminar too, all of this moment about what is it that we're trying to accomplish in looking comparatively. And so this book is very much of that moment, and yet on the leading edge, and creative and the forward thinking even at the time.
And also, I guess I think this is something that you point out, his insistence on the need to look at legal institutions and legal doctrine, etc., and its social and political and economic context. Today, I mean, that's sort of mainstream mostly. But to stress that at that time, I think that it was remarkable in many ways. Of course, as you also point out in your prologue, most of the book is straight doctrinal analysis of Argentine constitutional law, but the first part of the book, the historical part, is very telling in that sense, don't you think?
Yeah, absolutely. So going back to the legal history angle, one of the things we talk about in our prologue is that this is an important moment in comparative. That is the moment in which he writes, an important moment in comparative constitutional law, comparative law in general, and an important moment in legal history. It's something of a watershed moment for these fields that are sort of taking in the insights of legal realism, and there's certainly a recognition of and a concern with understanding context, social consequences, making sense of the law, not only with purely authoritative legal materials, but with what are understood as non-legal materials. Of course, part of what happens out of this moment is that definition changes. What is considered legal material and authoritative interpreters of the law gets transformed. So this is a very early moment in that sort of change in thinking. And we think that the book shows an awareness, and then at the same time the inevitable limitations of predominant scholarly forms as they exist in the moment. So in the prologue we talk about how legal historians, leading legal historian Robert Gordon has written about how historians were talking about external legal history before they were doing it. So doing external as opposed to internal, looking purely at the legal documents and at courts and at authoritative legal sources, and rather doing external legal history. People talked about it before people did it. So Willard Hurst is considered the founder of modern legal history. He was the first legal historian to do external legal history. He's doing that in the 1930s. So it's happening, but it's still new. And he sort of initiated a transformation in the scholarly field that has lasted to this day. And in fact, the prologue, we begin the prologue with a conversation about historians thinking about what our next move is. And part of what you get from it is, how hard it is to make the next move. There's a bit of a discussion of whether we should make the next move, because that methodological turn is just so powerful, and so sort of opens up such a broad arena of investigation, that it's what happens for the next, for the next 80 years, if not more. So to expect more than doctrinal analysis, a straightforward account of judicial opinions from somebody who's, writing their first comparative work and just learning about Argentina himself would be a lot. And it is impressive and admirable that he begins with this historical discussion, which very much contextualizes the Constitution in Argentina's history and experience and thought before he turns to the influence of the U.S.
So now we sort of navigated from Amadeo's book to your text, your prologue. I would like to talk about your prologue, and which I enjoyed very much, I must say. And I also want to say that I thought that you made a great job doing that work of excavation, and also one thing that I found interesting was sort of like the institutional part of this dimension of this, the fact that you were from Northwestern and from Colombia and all that. I imagine that both institutions got involved somehow, apart from you, in this project. So this project has that institutional dimension, which is very interesting. If you want to say something about that, but if not, we'll go back to your prologue.
I think we could both say, so as Erin mentioned before, she ended up working with librarians to try to get more information on what Amadeo took and whether it was possible to figure out. And unfortunately, they couldn't get class lists, but just the fact of working with the librarians on this, and now their awareness of his alumnus status is a feat in and of itself. And for me, it was the same thing. I just went exploring in the library and had several librarians pulling student notes for me on the prior comparative constitutionalism course that had been taught in the late 19th century, and then these seminar materials. And for me, I confess, I had never looked at these materials in the library, not just on the seminar that Amadeo took, but just these student notes. It's just such a wonderful set of archival materials to see these, longhand notes taken by, they have Teddy Roosevelt's notes from, as long as he lasted in law school, which apparently wasn't long. So it was a really fun project to participate in and to bring the institutions into as well.
And we thank you for it. Now, back to your prologue. One of your sort of sections is titled Reading Amadeo as Amadeo, which I found interesting. And in that section, you sort of dedicate a good portion of your text, about a third of your text, to point out what you call an omission in Amadeo's book. And I found that interesting. You dedicate a lot of your text to talk about something that was not in the text in Amadeo's book. And that was his treatment or non-treatment, or treatment just in passing, of the question of the territories in the Argentine nation as compared, let's say, to the territories in the U.S. Would you like to say something about that and tell us why did you think that was important to bring it out?
For sure. I would love to say something about that. I'm sure Erin would too.
I know that you would.
So I am unapologetically Puerto Rican and unapologetically interested in matters Puerto Rican and unapologetically interested in the territories. And
Right.
I spent most of my career thinking about the U.S. territories and most of my life thinking about Puerto Rico's status as the territory. And I could not resist speculating, because in the end, it's, it is speculation, but I just, gave myself together. We gave ourselves the liberty to sort of imagine imagine Amadeo's experience, just admittedly speculative. Okay. What's he thinking? And then of course, reading the book, we see there's this mention of territories, but it's passing. It's not like he doesn't know they're there. He knows they're there. He mentions them, but he does not examine them or their place in the federal system of Argentina in any detail. I also teach constitutional law and have spent a lot of time, more thinking than acting, I think, about the problem of how centrally important it seems to me to understanding American federalism, to be aware of the territories as well as native sovereignty. Okay, the idea of dual federalism is really, there's a truth to it, but it's a fiction, and more importantly, it's really an erasure. I just 2 days ago taught McCulloch and get to the part where Justice Marshall is talking about whether the people or the states created the Constitution, and I hear myself saying dual sovereignty, and then I have to stop and say, I'm not really sure this is on the test, but you want to know dual sovereignty is not accurate. Okay, so right. This is I'm always worried about this. So we noticed that he mentioned the territories, but didn't really make much of them. And then we started exploring the seminar materials. So we found his seminar paper, as we talk about in the prologue, as well as the seminar materials, the materials put together for the seminar. The seminar paper that he wrote begins by making exactly this point. He says you cannot understand a federal system without understanding all of the different entities that exercise governance powers. And then he explains what they are, which in Argentina, as in the US actually, there's a federal government, there's a federal district like the District of Columbia. There are provinces. There's an asymmetrical relationship of some kind between the federal government and the provinces. Then there are also national territories, and that's a different kind of asymmetrical relationship. And so it's just a few pages of his seminar paper, but he's clearly mapping out a project that he is not surprisingly interested in pursuing. And it's not just because, he's Puerto Rican, but because he's Puerto Rican, he knows that you can't understand federalism by looking at a duality. And so that's why we decided in the prologue to write about and basically speculate, why is it that somebody who doubtless knows, about territories and their importance to thinking about federalism. And in fact, we can show it in the seminar paper, were there to be any doubt. He was thinking about them. He thought one had to think about them. And then in the book, they recede. And then we offer some guesses as to why that happened.
Yeah. And can you mention some of those guesses for the benefit of our audience?
Yeah, sure. Do you want to mention them, Erin, or should I? Okay. So yes. So if I can remember them all, I will give you my guesses now. I think they'll overlap. So one is that maybe his professors waved him off of it. Just
but why?
focus on the central topic here. Maybe his publishers said, how about you leave that for later? Okay. This is already enough novel material for an English-speaking audience. Maybe you just study the territories at some other time. Maybe, so this is, further speculation, but maybe it's because what Amadeo himself thinks of federalism as having, not to overstate it, but, an ideal form. This really ought to be the federal government and the provinces, and the provinces all have their equal footing, so to speak, to use the phrase we use in the United States, and territorial status is transitional, which of course is how it was understood in the United States, and and then matters get complicated, as I don't have to educate anybody watching this video, they know. So the guess is, maybe Amadeo is saying when we're doing federalism, let's do federalism, and that's equal provinces of equal stature, jurisdictions of equal stature. But again, that's just a wild guess. Maybe not so wild. Maybe not so wild guess.
Yeah. Well, they're interesting. And in fact, if his mentors sort of advised him to sort of leave that subject aside, that could have some explanation also. I mean, why would they do that? And at that time, this is the early 40s, late 30s, maybe one explanation could be that the territories were not deemed an important topic by his mentors at that time, or that they were not deemed an important topic by Colombia or by the legal academy, the U.S. legal academy in general. Could that be an explanation? And that goes, I think, to the points you just suggested about this sort of invisibility of the territories in U.S. constitutional history. That's something that we've talked about in the past, and that, like, as you know, legal scholars like Sanford Levinson, etc., have sort of pointed out, this sort of how the territories have not been part of the constitutional canon in U.S. Jurisprudence. So maybe that was an explanation, or maybe it was a very complicated time, the 40s, and the war, and whatever. So it's an interesting question, I think, that you raise, and I think it would be worthwhile for someone, perhaps somebody else, or you yourselves, to try to dig more into that, and that, what was the and I think this might tie with what I mentioned before about this institutional support he got from people like Rockefeller and Roe. Roe, as we know, knew Puerto Rico very well. He had written about Puerto Rico, and so he knew about the territories, about the territorial question. He wrote about the insular cases extensively, and so maybe this was not the right time to talk about that. I don't know. I'm just speculating, like you are. But
I think all of those guesses are good, and I think it's one thing. So for sure, territory is not seen as quite as important. But among this group of people who are interested in comparativism, you'd think, well, more not insular thinkers, these professors, and certainly not Amadeo. You might expect it. More of an interest. So we assume Amadeo himself is interested, and this is why I brought up sort of teaching constitutional law. Like, it could be that his professors or he himself in writing this just feel a responsibility to sort of address the dominant topic or the mainstream topic or the thing that really you can't claim to understand American federalism. So just when I mean Argentine federalism, unless you understand the provinces and the federal government and Buenos Aires and and the territories secondary. Just like when I teach McCulloch, I'm getting paid to make sure they understand what the stakes are of the debate about whether the people of the states created the Constitution. Nobody's paying me to explain to them what the territories are. And of course, I'm a scholar, so I can explain whatever I want, but I do have a responsibility to make sure they know what they're supposed to. And that pressure alone, the dominant topics sort of reproduce themselves because of the nature of teaching and pedagogy and scholarship, et cetera.
I mean, one counterpoint, and this comes out of the seminar materials, is that, a seminar is a smaller course. It's usually an elective. People choose to take it. You as a scholar have a little bit more control over the content. And in the seminar, the professors chose to, in sharing a case about the Philippines, chose to edit that case in a way to omit the detailed and nuanced analysis of the court on the Philippines as a territory, just cutting that out completely.
Yeah, that was interesting.
Yes, the court actually in that case hypothesized, it did discuss the Philippines as a territory, and then it hypothesized that let's just hypothesize that it's a foreign country, and then the professors in editing the materials just kept the part about the Philippines being a foreign country, which again, one can apply a more sinister interpretation to it, but no, it's just, this is where the comparative stuff happened, and so there it is.
Right.
And so what did Amadeo think when he read this opinion? Did he, did he argue? Did he say, I get it? How did he feel? No way to know.
Right. That's an interesting point that you make. Now, we've been talking about the choices that Amadeo made while writing his book. Let me turn a bit about your choices when writing your prologue or your foreword to this book, and of course you had to make many more choices because it's a much shorter text. I understand that. I understand the problems of writing a prologue. You have to choose, but what I just wanted to ask you about the choices you made, the things you actually left out in your prologue about Amadeo's book. And one of them that we talked about previously is the fact that his book is divided into 3 parts, as you mentioned. The third part is dedicated to the protection of rights, individual rights. And my question was, why didn't some of that come into your own text? Perhaps it's, I don't know why, but perhaps the strictly doctrinal analysis there is not sort of worth noting in any sense. Perhaps rights was not something that was prominent at the time. Perhaps rights now are sort of in everybody's minds now, and it's not worth highlighting. Whatever. Could you say something about that?
So thank you. I mean, at one level, our own omissions are extremely sizable, right? That you're generous to say we covered part 2 on federalism. I'm not sure we did that either. I think we do talk about part 1 because of the methodological contribution that part 1 is. And as Christina was talking about earlier, if he had been able, which I don't think he would have been at the time, to think about parts 2 and 3 with that same level of methodological creativity, then you would not have seen just doctrinal analysis. You would have seen analysis of the parties who brought these cases. Why? What is the political economy of litigation at the time? How do you think about groups of lawyers organizing? Who's in court and why? And there's not scope for that either in the book because it would have been too long. Each part would have been its own book, but also just at the moment in time of methodology. So some of the interesting questions about the results, once you move away from just pure lawyering, what is the doctrine, are rooted in that kind of additional methodological creativity, that additional reliance on various sources that just wasn't possible at the time. So it feels a little unfair to beat up on someone for not doing something that really wasn't, part of what the scholarly literature was at the time. So I think that's part of it. Another thing that is interesting about it is the way in which the Argentine court drew on the U.S. court and the U.S. Constitution to create implied rights.
Right.
So implied rights including habeas corpus, the right of assembly, right of bail, but also Lochnerian economic rights. And so there's also a sense about these portions of the book that the assumption about whether or not this is good or bad, right, is a little difficult in light of the subsequent U.S. history. And so that may also, cause us to shy away from, treating this as an analysis of how we might think about it today. Again, just not really feeling fair. Like, we need to view it as it was at the time it was produced. And, and that's part of the historical aspect of approaching this and writing a prologue at this time. And Christina's great strength of being both a lawyer and a historian to think through this. One comment I wanted to add, sort of reading Amadeo as Amadeo, because this is published in English and most of the book reviews are in English, and many of them are even in British law journals, all over. The assumption of the Anglophone community is that Amadeo is Argentinian. And so we see in book reviews, this learned Argentine scholar, not scholar of Argentina, and so I think that's another important point or moment to kind of reclaim and say, wait a minute, right? One of the great things about comparative work is that you can learn another system. You do not necessarily have to be of that system to learn deeply about another country and another constitutional regime.
Okay, great. So are there any recommendations that you would make for future students of Amadeo's work? Any sort of lines of research that we should think about? Or if you were doing further work in that, what would you like to explore, for example? Is that a fair question?
Oh, for sure. I mean, there's so many things. I mean, just to pick up on the discussion of the last question, I think that part of the way we thought about what we were doing was we were almost in a miniature way. I mean, it's just a brief prologue, but we were kind of modeling the thing we were talking about. So, this is we have a very external relationship to the text. It was all about like who we are, where we are, who is he, what's he doing, where was it happening, and then we didn't go in there and do anything internal at all. That what's so marvelous about this series is that the book is now available unquestionably by a Puerto Rican author. Nobody's ever going to be confused about that again. And so, okay, so where would we take it next? I mean, so for me, I would love to explore that, as we were talking, I thought about this then, and I'm thinking about it now. I'm glad we're talking about it now, because I was thinking, where could I get the papers of these professors? And could I find out, was there any discussion of not just deleting the part on the Philippines that we got interested in, but was there discussion around the creation of the materials about what is a sort of worthy comparator and what's not? And what do we include, for sure, right? What do we include and what not, and why? Just conversations, any record of conversations about how to edit these materials would tell us about the methodological challenges they faced. So one could explore, as a legal historian and as a comparativist and as an institutional historian, about law schools and legal pedagogy. And there's so many things you could find just by digging deeper into just the records and papers of any of the people involved here. There's also, I mean, so for anybody who is, expert or trying to develop expertise in Argentine constitutional law, This is essential. Where was it then? How does it develop? How does the court think about federalism in this moment in time? This would be an essential source for anybody trying to develop their doctrinal understanding. So that's not really the direction that I would want to go in with this project. I would want to pull the papers of these professors and see if they had an argument about what to do with that Philippines case and take it from there.
Right.
I mean, I think I would just add, and Christina put it so beautifully, right? We did approach it externally. And just because we didn't choose to approach it internally doesn't mean that there's not great value to the book, not only just for future art scholars of Argentina, but actually there's tremendous data on different doctrinal points in the book. So for those of us, and this is something I'm interested in judicial power, and how do courts decide when to cite other courts and when to draw on jurisprudence from other systems, which systems to draw on? Is it useful as an emerging court to rest your decisions on a legitimate long-time court like the US Supreme Court? We've seen literature and political science saying that that is, of course, true and a methodology that emerging courts use. How does Argentina fit into those conversations? And could we use this snapshot of the court at a particular time to actually really enrich some of those questions about judicial power and the development of strong judiciaries around the world? So there's a lot that people could do with the material.
Okay, so this has been a wonderful conversation, at least from my point of view.
Ours too.
And thank you so much. First, for agreeing to take on this project, which to us is very important. Secondly, for having put so much effort, evidently so much passion into your work, and for sharing your thoughts with us today. And we hope that we continue collaborating in projects such as this, because I think that this has a lot of potential. And your views about Amadeo and about the book and about this kind of work is something that certainly will be very helpful to all of us here in Puerto Rico. So thank you so much, and I hope that we can meet again at some point and talk about another interesting project.
Thank you.
Thanks to you and to the academia. It's been a pleasure to be part of this the whole way. And thank you, Erin.
Thank you, both of you. Bye.
Bye.